Good day to you all. I'm sorry that I cannot be with you in person, but you will understand that I'm currently at my home in New Zealand. It is a pleasure to provide this explanation of the new topic in the Commission's long-term program of work, due diligence in international law. I want to thank the Codification Division for making this presentation possible, and my colleagues on the Commission who contributed to the development of the topic. I also want to thank all of you for your participation here today. Due diligence has a long historical pedigree, dating back to the late 18th century. In recent years, we have heard a lot more about it and in various contexts. For example, in its advisory opinion on climate change, the International Tribunal for the Law of the Sea used the term frequently when explaining the nature of the obligations to prevent, reduce, and control marine pollution and to protect and preserve the marine environment. Due diligence has also featured in the pleadings and declarations of some ICJ judges in Nicaragua v. Germany. This has been in relation to the provision of military aid to Israel. In a different context, some states have referred to a due diligence obligation when explaining their positions on international law in cyberspace, and others have not. Looking forward, due diligence is likely to feature in current cases pending before the International Court of Justice. This quick review shows that due diligence is often used in different fields of international law. Sometimes its meaning and how it is interpreted differ. In addition, the legal character, scope, and content of due diligence are not well defined. This caused me to reflect on the need to identify a more systematic and comprehensive approach to due diligence. To be clear, due diligence, as referred to in this proposal, is based on the dictum in the Corfu Channel case. In other words, that a state should not allow its territory to be used for acts contrary to the rights and interests of other states. Due diligence envisages that there is a standard of conduct which requires states to act reasonably with regard to others in the international community. This is especially important in an interconnected world where the actions of one state and the persons subject to its jurisdictional control may adversely impact on the rights and interests of other states and persons. While states are sovereign within their territory, they are also members of the international community. A standard of conduct is expected of states that they will act reasonably with regard to the rights and interests of others in the international community. Due diligence gives expression to this. I expect that you will have three main questions on this topic. What would it entail? Why is it important? And why should the International Law Commission address it? I will seek to address each of these in turn. To answer the first question, what would it entail? The topic would survey state practice, judicial decisions, and doctrine on the obligation in specific areas of international law. From this survey, it would seek to identify common elements of due diligence that are applicable broadly in international law and are not dependent on the particular primary obligation to which due diligence attaches. In particular, the topic would examine a range of issues related to due diligence. These would flow from the survey and will assist in delineating the scope and content of due diligence. It is envisaged that these would include examining whether there are certain conditions under which due diligence arises that are not dependent on the primary obligation, whether there are particular circumstances or capabilities of the state concerned that should be taken into account, whether it is a variable standard of conduct and the nature of the required standard, the nature and degree of the harm which would activate due diligence, and issues related to risk, knowledge, foreseeability, and reasonableness. The objective is to identify the legal character, scope, and content of a due diligence obligation in international law. This will also entail consideration of the legal character of due diligence, such as whether it is a standard of conduct, an obligation, or general principle. To avoid the topic being overly expansive, the topic is confined to certain aspects. For example, it would consider only due diligence required of states, not of international organizations or of business operators themselves. It would not address the operationalization of due diligence, nor would it undertake a micro-level analysis of individual primary obligations. And it would not directly address issues of state responsibility. However, as due diligence is associated with primary rules of international law, it should assist in clarifying the relationship between primary rules and secondary rules of state responsibility. Turning to the question of why it is important, the topic fits the criteria for the selection of topics for the Commission. It reflects the needs of states, is sufficiently advanced in terms of state practice, and is concrete and feasible for progressive development and codification. But there is a more fundamental reason why this topic is worthy of being pursued. The International Law Commission and international law must be able to respond to the contemporary challenges of today's world. These include the challenges of new technological advances and the increasingly significant role of non-state actors, which operate across national borders. Due diligence can provide a framework to guide states in how they can meet these new challenges. Finally, the question of why it is appropriate for the International Law Commission to consider this topic. One of the Commission's most useful outputs has been its articles on state responsibility. Due diligence appeared in the early work of the Commission on state responsibility. It also appeared in its parallel work on transboundary harm. But the Commission has never comprehensively addressed due diligence as a standalone duty. And the place of due diligence within the system of state responsibility is not clear-cut. A topic on due diligence in international law would build on the past work of the Commission. It would complete what some see as the Commission's unfinished business. And because of its cross-cutting nature, it would benefit from the combined legal, academic, and practical expertise of the Commission. As you all know, the Commission has a role in the codification, progressive development of international law. The primary purpose of this topic would be the codification of the practice relating to the obligation of due diligence in international law. Given its practical orientation, the preferred output of the topic is that of draft principles. These should give concrete guidance to states on the necessary requirements to enable them to meet their due diligence obligations. In this presentation, I have sought to provide a brief explanation of the syllabus for the new topic. One of the real benefits of the Commission's long-term program of work is that it provides the opportunity for states to have input into new topics. The Commission can then consider the views of states in deciding whether to include a topic on its program of work. The views of the Sixth Committee and states, not only on new topics, but on all topics, are therefore crucial to the Commission's work. For my part, I would very much welcome and look forward to hearing the views of you all on this topic. And I also look forward to seeing you in New York during International Law Week in October. Thank you once again for this opportunity to present to you on the proposed new topic of due diligence in international law. I wish you all the best. Thank you.